body, we are now in a situation where the tribunal has become one of the few legal bodies to be able to operate and operate more frequently than it did before the lockdown. One of the ironies of the current situation is that the tribunal has a limited number of permanent judges, a lot of part-time judges and members. They all do other things, and of course most of them now can't do other things, so the tribunal is now able to hear cases and is hearing them fairly efficiently, subject to the limitations which we'll discuss of the use of IT. Where we are is that most hearings are taking place, if it's possible to do so. Examples of hearings that shouldn't take place are ones, in my view, where really it's essential that questioning is done live. And that would be particularly relevant in disability discrimination cases, for example. And it could be if there is some very significant questioning of experts on one or the other side. That itself doesn't lend itself brilliantly to the new system. However, parents may want to go ahead despite the limitations, simply because they want a decision, they want a place for their son or daughter. However, there may be reasons why they should be advised not to do so. Those that are being cancelled are largely ones that can't be completed because the school can't offer a place, or decisions can't be made due to the current situation about the next school. So those are examples of limitations in the system. What actually happens? Well, hopefully, although the guidance refers to a mobile phone and a smart TV, I've never seen a smart TV used, but I would strongly advise against a mobile phone and used. It's been quite plain that the mobile phone has its limitations. They are too small, and normally you're dealing with a number of people on the screen. Yesterday's case, for example, even though none of our experts were necessary, there were 3 from the local authority, a representative, myself, the client, plus 3 members of the tribunal. So to look at all of those participants on the screen is pretty difficult on a mobile phone. So I would strongly advise use a laptop, a desktop, or a tablet. Does the technology work brilliantly? Well, it works better than expected, firstly. I understand, and this may be just apocryphal, that the technology was developed for parents who couldn't leave their home due to having a severely disabled child or due to themselves being disabled. So the technology has come into its own due to the crisis, and that is another irony of the current situation. So what has happened from experience, and obviously I'm talking from experience, so I suppose you might say this is a sort of Uncle John talk rather than a cutting legal analysis. And I'm going to concentrate on video hearings, and if I don't get very far with the case review, I think that's less important because hearings are here now and going on. And as Haley's already told you, the tribunal is keeping to its timetables. Timetables have not been halted, and it's moving. In July, when the Department of Justice answered a question in the House of Lords, which I drafted for Lord Lingfield, they admitted that 78% of first hearings were being cancelled. We are now finding that first hearings which are being fixed are taking place, obviously subject to those hearings being capable of taking place and going ahead. So the change is pretty radical, and one thinks that what might happen is that at the moment they may forge through as many hearings as possible, but those that are not possible will stack up. So it's a very good idea to try and anticipate the future, and I'll come back to that later, and anticipate what may happen, so that if you can't complete a hearing, you might well fix a date with a view to events taking place as quickly as possible in, say, September or early October, probably early October, because I can anticipate when people go back, there will be relative chaos in setting things up and in assessing and putting the package together, as it were. So starting off from you're going to the hearing, does the technology efficiently work? Well, the answer to that is a lot of the times yes, and sometimes no. I had a discussion with one of my colleagues and friends who may be listening, and apparently the technology was so bad that they had to turn it into a telephones directions hearing. Yesterday's case locked the judge out twice, I think, me out once, and one or two other participants out a few times. It was a relatively simple case with most things agreed and some evidence on some very limited issues. In fact, some 5 limited issues, which came down to 3 at the end because the rest was agreed. And it took all morning. It would have taken, in a live tribunal, something like an hour to an hour and a half at most. So it was double the length due to technology problems. Another case, we had the judge's home technology was so weak that it took us 2 hours to get it running efficiently so you could actually hear properly and participate. So I've not had a case where the technology was so bad that it had to be abandoned, but the technology as such is, for the purposes of where we are now, better than expected, but well short of ideal. So you may meet disaster, but most of the time it will work. And I'll consider more how the hearing goes on and what happens at the end, because there's things to think about there. So, preparation for the hearing, what are the essential issues? Number one, you can't really negotiate a working document at a hearing of this nature. It's just not practical or possible. So firstly, make sure, as part of the team, and certainly representatives should make sure, that 1, there is the last version of the working document available, and 2, that anything that is capable of agreement is agreed, and anything that is capable of dispute and evidence on those issues is clearly flagged up. And the other issue is that in order to prepare, the latest working document needs to be checked that it is the latest working document. Problems have arisen where not everybody's had the latest working document, and that needs to be maybe obvious, but that's a check that needs to be made, and it's an issue that people aren't properly checking on. The next issue is late evidence. The participating team needs to make sure, 1, that they have all the late evidence, and 2, everybody must make sure that somebody has, and that should be the lawyers obviously, have sent to the tribunal a summary of the late evidence, in the sense that it's recorded that we sent you the late evidence, namely the report of Mrs. Bloggs or Mr. Bling on X day. We sent you the Ofsted report of the school and the assessment of Jamie on X day. Please inform us if you haven't had those documents by, I would suggest, 12 o'clock the day before. And we are assuming that if we don't hear back, you've had all these documents. Hayley and I had a case recently, just before lockdown, where the tribunal made various orders and a huge tranche of documents was sent to the tribunal, never sent to the panel. We are talking about the most essential documents in the case that eventually won the case. It also meant that the case for two brothers could not be heard on the same day, possibly. I don't believe that they could have been heard together, but it might have made some progress with the second case, which would have been very helpful to the parents. So check that the late evidence has been received and make sure it is recorded, and that should be clearly recorded not only to the tribunal, but to the local authority. However, that is not the only housekeeping that needs to be done. An essential part of preparation before the hearing, particularly because of the nature of these hearings, is a team discussion. Now, we often did have a team discussion before the case in the consultation room in the building where the hearing took place on the morning, or in the restaurant. That needs to take place now, in my view, something like 2 days before, so that, first of all, we're clear that there's no further agreement possible, and we're clear on the areas of disagreement and the evidence that's essential on these issues. That means people need to identify the essential areas of evidence in their bundle and be able to say, well, I disagree with X dispute in the working document, and I put forward our position because at page 54 and 734, that's the evidence. So these roundtable briefings, as it were, are absolutely crucial and have proved, in my view, to be decisive on the cases that have been heard so far, and have shown that the parents' team has a command of the issues which sometimes opposition does not show, and that helps as well. But it also helps because there are possibilities that witnesses have moved forward and can agree things or have noticed new issues which weren't immediately apparent. So the last thing is that it's still my view that there should be a brief, quarter of an hour, 20 minutes if possible, roundtable consultation by telephone on the morning of the case. 9 or 9:30, cases start at 10, just to make sure everything's been covered. And you'll be gathering that it's my view that you must be very much more rigid and, if you like, autistic in the preparation of a case than you might be if it was a live hearing and it wasn't so condensed, because these hearings are condensed. The other issue I would draw attention to, and this became apparent, I think, last Friday, is that the tribunal has some internal directives which one of its expert members made clear to the chair in an amusing manner. She's a great lady and I appreciate her very much. But she made it clear to the chair that there are internal directives, they shouldn't go much beyond an hour, and I think it was limited to an hour because of it, gazing at the screen, and they should be finishing at 4. And these are health and safety, I think, advices. So that's something to think about, there will be frequent breaks. I have heard it said to me, and I would agree with it, that these hearings, if going for a full day and are hotly contested, are more tiring than actually sitting there live. You'll be told to mute and only come in when you're asked to come in. You can wave or be involved in an interchange, but it's very difficult to be involved in an interchange without an intervention by the chair and without an invitation. So the conducting the hearings is very difficult to have spontaneous issues arising. You need to, as it were, hold them, come in as soon as practical, if necessary, waive your wish to participate. And do remember, you can't talk among yourselves. So if there's an issue you need to discuss, you need to say, well, Chair, I need to discuss this with our team and our legal representative. We need a break, and they will give it to you. But you can't really spontaneously deal with these issues at all. So that also needs to be taken into account if something comes up. The hearings generally, as you probably gather, are very much more focused and more targeted. And certainly some chairs are asking whether you consent to this type of hearing. We've always consented, but there are some hearings which, last week I had a CMC, which I think the chair wanted to push to be heard. And if we're asked for consent, we'll refuse. That's a disability discrimination case. But you need to very seriously consider with your clients whether you're consenting to such a hearing. The other issue I think is very important. And one reason why those who work with me will say, oh, that's the same backup as when he does the tribunal, and that's exactly right. The reason why I prefer to use a designated conference room is that if something goes wrong, and it does, so that some of our experts can't get their technology to work or can't get through, we can contact them and say, you're not working, it's not working. You can come in on the phone, or we can say, okay, we better tell the tribunal you're having difficulties, and we can resolve those issues. So that helps. Also, if there's a problem with technology, it can be resolved by some assistance. If you're at home and it's down, it's down. Remember that. So that's another issue to be considered. So the other issue I would draw attention to from experience is length of hearing. Number of hearings we've had have gone on for a full day, but have not completed and gone to written submissions. The cases that have completed are firstly a part heard case that was part heard from before the lockdown. That did complete, but it still took to about 3 in the afternoon. A case where the local authority actually had no evidence, but decided they wished to test the evidence. There were 2 of those. And in one of those cases, the tribunal adjourned for, again, some form of written submission. And lastly, a case where virtually everything was agreed yesterday, bar some very few 5 discrete issues, which the client still wished to pursue. That was able to be completed, but did not complete as quickly as I've said as it should. So expect the case not to fully finish. One case is on the video hearing has gone part heard, but only one at the moment. But all those that went to written submissions, I suppose, could have gone part heard, were much better dealt with by way of written submissions. So therefore, do remember that you may not get to a point where the hearing has been completed, but the role of an expert witness with written submissions will be finished, but the parents may be invited to provide their viewpoint at that point. So in short, and I'm going to turn to expert witnesses working in this current climate in a moment, what's our conclusions? Well, I think in general, the hearings work, subject to being sure you're happy that they go ahead. Where they can't work is where schools can't assess, or where the child is too complex to have an offer on the papers and by way of a Zoom assessment. We have some cases where specialist schools or independent special schools are just not offering assessments, and they have to be done after the schools go back. And some cases where the parents have said, there's no way that James, Johnny, or Jenny would necessarily be able to cope with the school unless they've been there and there's been a successful assessment. So while it is possible, as I'll deal with, to get offers of places, that depends on the individual child, their particular makeup. I mean, they may be still quite complex and you may be able to offer them a place, or they may be quite complex or relatively simple in some ways, that their needs are not multiple but are severe. That's why they've got a plan, but still it would not be wise for them to attend a school where a place is offered solely on paperwork. And another problem, of course, with paperwork is that the school will need a working document which is up to date. So a number of expert witnesses have asked questions about working where direct assessment is not possible. Now, it is possible to have the evidence available without a direct assessment, and it can be done based on paperwork and reports from the school, direct contact with important members of staff at the school, and using Zoom or whatever, Skype, etc. And those cases are proceeding. Therefore, experts such as psychiatrists, educational psychologists, and clinical psychologists can assess, and speech and language therapists can assess. Where I think it would be more difficult is for, say, physiotherapists and occupational therapists for a start. And I think it would be much more difficult for an educational psychologist to deal with a case for, say, Trelaws or other schools where, or specialist placements, where you're dealing with those who are much more physically disabled as well as with significant learning difficulties, or legal, educational, medical needs. So the situation is that we have worked on cases and where it has been possible, a Zoom or the equivalent assessment with a consultation with the current school or the school the child is proposing to go to, and the current school if it's a transfer, as well as, I would suggest, well-documented evidence for the educational psychologist or other expert to work on. It is therefore, in my view, possible to produce a reasonable case if the local authority also does not ask for an adjournment or the tribunal refuses them to have an adjournment and take the matter to a hearing. It therefore should be possible to conduct appropriate assessments. What you almost certainly can't do is visit the school proposed by the parent. And it may well be in this crisis, and I point out that it's certain we will be in a huge recession. That means that the legal team and the experts have to accept that you may have to produce an initial report, and then you'll have to go to the school, and you may even have to see Johnny, Janie, or Jenny in situ, and the charges are going to have to be reduced or not made, because previously you would have done that at one charge, and you're going to have to cut your cloth according to the economic circumstances. And make no mistake about it, the predictions that are coming through publicly are that there is going to be a massive recession, and we need to take that into account. You also need to take into account that if you are doing the assessment and the assessment needs the final package, the school visit, or seeing the child in situ in a school, and that can't be done by Zoom, then you're going to have 2 stages in the report, and you're going to have to seriously consider costings on those issues. Obviously, that applies to the lawyers as much as it applies to the expert. But you should be able to do cognitive assessments, and if Janie, Johnny and Jenny are at a particular specialist school, then, and they're there, then that will give you the feedback, and you may be able to actually assess them on Zoom or Skype as well. So reports can be done, assessments can be done, and the tribunal recognises we have to do our best. And it may be possible to work on the paperwork plus Zoom assessments plus reports, orally or otherwise. The cases where this has been done so far are pretty well documented, and clearly cases where there is a good paper trail, if I can put it that way. And obviously one benefit is that the local authority may therefore not be able to put up much of a contest, and that may be very helpful. It's therefore possible to do new hearings having prepared on that basis, and there will be some that can be done. Others, it may not be possible to do so. So where are we with the whole situation? Well, we're doing our best, I think, and it's not ideal. Video hearings will be used more frequently in the future, but don't think they're a massive solution, because I'm going to have to regretfully agree with Jacob Rees-Mogg for the first time, and say he commented on Parliament that the digital hearings, the video hearings, lacked spontaneity, lacked inspiration in some ways, and lacked sufficient interconnection and interchange. All of those apply to hearings of this nature. One of the hearings we did, the tribunal, on the first day it was formally conducting these hearings, which I think from recollection was the 23rd of March, but I might be slightly wrong. And I'm not going to get on to judicial review at all. So that paper is available, will be available to all who want to see the judicial review paper, because of the importance of, I think, discussing where we are. But the tribunal moved it from Exeter to Bodmin, which was very marvellous, and then suddenly said on the Friday, we're taking it over to video. And that actually was very useful to everybody, and everybody who should have contributed, bar one witness who hadn't seen the child and hadn't produced a report saying more than this is what our health service offers, and didn't deal with the child's needs at all. So the tribunal didn't grant an adjournment to get that witness there. The hearing was very efficiently dealt with, but it still went to written submissions. And I think that particular hearing, a Devon case, was very suited to the situation. The others, I think we would, in virtually every one, have seriously considered a live hearing. And I think in one where the local authority, I've got a couple of minutes, were arguing against the parent case for supporting a child in a mainstream school with very complex ASD needs and very grave anxiety difficulties. And they were arguing about a package which was regular visits from an experienced ASD teacher, a ASD trained learning support assistant, sensory integration occupational therapy, they agreed the occupational therapy, and speech and language therapy on a regular basis. I think it was weekly, I'm fairly certain it was weekly. I think that hearing, which went to written submissions, and quite extensive written submissions, which we won. Oh, and we wanted a clinical psychologist and got one. I forgot that. But I think they would have conceded a number of issues during a hearing. So it doesn't allow concessions. It doesn't allow second thoughts. So they are dealing with the emergency, and they will be on offer, but the offer needs to be carefully considered in the future. At the moment, it's the only show in town. So I'm about to hand over to Nicole Lee, who's obviously be far more charming and erudite than I will be, and I hope that's been helpful.